right, good evening, everybody. This is Jonathan. I hope everybody is doing well this week. It is August 7th, 2024, and I hope that where you're at, it is not too hot. It's a little warm in Atlanta. Today was in the 90s with a lot of humidity, so it was definitely kind of a warm day, and I think that we're probably going to have a few more warm weeks, and then September will be here, believe it or not, and I think it should hopefully start to cool down. So without any further ado, let's kind of go ahead and get into some of the questions. And I know Christina, who's always there, says hello from California, and she thought I was playing tennis tonight. I was not, because my partner wimped out. It was too hot, so he canceled it. So we did not play. But hopefully I'll be able to play this weekend and next week as well, because that's a good way to get some exercise in the fresh air. All right, GI Jose, how much notice do you need to take a case before a hearing? Not a lot. I mean, if the file is complete, I can usually get ready in a couple of days. The issue a lot of times I find is that when somebody reaches out to me and says, will you take my case over? Either A, they've already got an attorney, which means that, I don't like to poach other attorneys' cases, so I would always tell them to work things out with their other attorney, but if the other attorney has basically said, I don't want to do it anymore, that person would need to withdraw and waive fees. That way my fee contract would be honored. And then I would need to make sure, secondly, that the file is up to date. And one of the things that, I talk about sometimes in my videos is when you are at initial and recon, Social Security gathers all of the medical information. At hearing level, the attorney, the claimant or the attorney has to gather it all. So it is much more difficult to jump in if let's say that there's 2 weeks remaining and there are, a year and a half worth of medical that need to be updated. So it kind of depends. But I've had cases literally where I get a file, 2 weeks before the hearing, a week before the hearing. I kind of know what I'm looking for, so I can kind of zoom through and find out what I need. But the more time, the better. And I will tell you that there are times when I will say to my client, we need to postpone this because there's just too much information that needs to be gathered or reviewed, and we're not quite ready. And I'd rather delay it for a couple of months and make sure it's done correctly as opposed to rushing in and doing it. So I don't need a lot of time, but I need enough time to make sure that it's done right. But again, after 30 years of this, I kind of know what I'm looking for. Have I had issues with judges not being able to get medical treatment during COVID? So the question here that Jose is asking is, if let's say there's a gap in treatment in 2020 and 2021, is that being held against you? No, although again, we're in 2024 now. So I think that 20 and 21, those gaps, there was a lot of telemedicine, there were gaps, it was not as big of a deal. But I think once we got to 23 and 24, I don't know that we can argue anymore that COVID is preventing people from going to the doctor, because there are ways around it. So I don't know that it would be a really good argument in 23 and 24. Okay, Social Security does not do an impairment code for my application. My phone hearing's on Tuesday. I'll keep everyone posted. I'm not sure what you mean MDI impairment code. I'm not sure what that is, but I certainly wish you luck on Tuesday. Jim, how important are medical source statements? I had one completed with less than a 4-hour workday. It has all my medical issues listed, would affect SGA. That would be very helpful. Some judges really, really rely on these medical source statements. I had a hearing today out of the National Hearing Office, and the judge, one of the first questions he asked me, and this is a judge who I think is actually a pretty good judge, but his hearings are very free form. They don't really follow a lot of order, and he'll just kind of, it's just kind of a discussion. But he said to me that one of the first things he said is, do we have any medical source statements here? So for some judges, that is a really, really big deal. So if you can get them, they never hurt. It's always a good idea to get them. If you have a good one, that can help. Now, let me also tell you, Jim, that if you have them, the underlying medical record needs to be consistent with the medical source statement. In other words, you have a medical source statement that says you're limited to 4 hours of working, of standing, walking, sitting combined. But the medical record doesn't really reflect that. There's no evidence of a, let's say a disc issue, if it's a back pain case, the record has to be consistent with the source statement. And I've had situations where judges will say that the medical source statement is not consistent with the underlying medical record, therefore we're going to disregard it. And under Social Security law, now that they've eliminated the treating source rule, a judge can do that. They could ignore a medical source statement from a treating doctor. Doesn't happen very much, but I would just say that there is, let's just put it this way, I think there's some suspicion out there that some people are getting their doctors basically to write these letters saying that they are totally non-functional, but the medical record doesn't say that. So you want to really make sure that the medical record and the source statement are somewhat consistent. All right, Mark says, I had my hearing and the ALJ says I can only work 2 hours a day. VE said no jobs in today's economy. ALJ and VE said I cannot do past work. VE said 2 hypothetical jobs I could do, mail sorter and probably credit card clerk. My lawyer's closing statement was, according to SSI rules, you have to work 8 hours a day. I can work 2. Yes, I think that if the judge accepts you can only work 2, then you win. Realize that sometimes the hypothetical questions the judge may say assume that individual can work an 8-hour day, just to kind of get a sense of where the medical record is. So again, if the judge accepts the hypothetical that says 2 hours a day, or the medical record says that, then you're in good shape. Realize that judges in hearings will give hypothetical questions. They may give 4 or 5 of them. And I can't tell you how many times people will email me or call and say, the judge said, ask the vocational witness a question, and the answer was I could not work. Then I look at the decision, and it turns out, or you listen to the audio, it turns out that there were 4 or 5 questions, and the judge picked the one that was least restrictive. And the other ones where the answer was no jobs, but that was not the one the judge picked. So you have to be aware that the judge can pick one of those, and that is reflective of what the judge thinks your residual functional capacity is. So don't assume that just because 1 or 2 of the hypotheticals gets the answer no jobs that you've won. Obviously you hope that it does, but I just, caution people, don't assume that because, 5 questions are asked and 3 of them get no jobs means you won. Because number 1 and number 2, maybe there were jobs. It's just, again, that's just how they do it. All right, Christina has been waiting 71 minutes. I hope this is worth it. And she said I was playing tennis. I was not playing tennis, as I said. It was I would have played, but my tennis partner says too high. Okay. K Wolf, thank you for doing this. My pleasure. You've learned a lot. That's good. Would a letter from my interventional pain management doctor help? Or is there a form or something I can give him? I think a letter would help. I think that, you can give him a residual functional capacity form. And I think I've showed everybody this before, but I'll put this in the notes where you can get them for free. That's one. And here is another place you can get them for free. And that's 2. So look in the comments where you can see where you can get them for free. So if the doctor will fill out a functional capacity form, that would be very, very helpful, because that really addresses the very, very specific issues in a Social Security case, work activity. We all wish GI Jose the best of luck. I told Christina that. That was okay. I mean to be talking about my tennis game. We have more important things to talk about, but my whole life appears to be an open book now. Joseph Cooper, how much SSDI would I get for deteriorated disc? I'm 54, worked all my life as a mechanic. I'm a contractor struggling to keep working with pain. I don't know if I can handle the pain anymore. All right, the amount you get, you need to get your My Social Security statement. Go to ssa.gov/myaccount. That's ssa.gov/myaccount. It will prompt you. You have to get a password and codes and all that kind of stuff, but you'll get your My Social Security statement. It will tell you how much you're going to get. So that will answer that. It also confirm that you have enough credits, which I suspect you do if you've been working all these years. So that's that. Now you're 54, which means the grid rules could apply. I don't know. Oh, there we are. Okay, I'm back. Okay, there we go. Okay, so I am back here. I'm sorry about that. I don't know what was going on there. That was on my end. It just said all of a sudden it froze. Okay, DD says, here I am, still waiting on my initial decision at 7 months. It's a long wait when you can't get at work because of disability. Yes, you're right. It is a long time. And I would say that if you've been waiting for 7 months, it might be time to reach out to your elected representative. Garrett says, hello, everybody. Hello, Ginsbergers. Never heard that one before. Okay. Jenny Joe says, hello, hello. Trish says, hello from Tennessee. Rodney, who is a loyal viewer, says hello. And Rodney, I got your package that you sent me, and I will, you wanted to get the recording, I'll get that for you. I just had a really, really busy week, so we'll get it for you. Okay, Adam, you got approved. Yes, you did, April 23rd. You should get your back pay. You know, I've noticed some delays. This is, you know, because I get paid the same time you do. And I've had situations where, you know, it's taking a lot longer than it should. I'm not really sure why. You know, I'm seeing fees come in for cases that were tried in May. So it's taking a few months, April and May. So I think we just have to be patient. I've called, and what I've, you know, on a number of my cases, and where I'm getting, what they're telling me is we're working on it. That's all I'm getting. So it does come through eventually, but I don't really know why it is taking so long, but it is. Rodney is looking forward to another great one. Well, I hope you were in the right place. Sandra says, hello from Bristol, Tennessee. Where's Bristol, Tennessee? I don't know where that is, but I've been to Nashville, been to Chattanooga, but I don't think I've been to Bristol. Powder Puff, how long did it take? So again, he got approved in April. In most of these cases are taking 2 years or so. Emmanuel, how are you doing? Hello and good evening to you. Rolando, I was denied at the hearing level under 216. I'm going to be 52. What happened to the grid? You mean the grid, not Greek. If the judge at 52, if the judge did not find you limited to sedentary work, which means sitting, you know, limited to, you know, no more than 2 hours standing and walking during the day, lifting 5 pounds, frequently 10 pounds occasionally, that's the definition of sedentary. If you were found to have more capacity than that, you could stand and walk for 6 out of 8 hours in a day, or you lift 10 pounds frequently, then you'd be at light, which means the grid would not apply. So it's becoming more difficult. Put it this way, I'm finding that more and more times I'm getting grid rule approvals for people over 55. Between 50 and 55, it's a little less common than it used to be. So that's probably what happened. They found you limited to light. John, good evening. Good evening to you. Okay. Garrett is saying hello to everybody. Guy said, I just got approved. Congratulations. Very, very nice. That's good to hear. It is hard. It is hard. Okay, we're saying hello. Jason says, I'm going through the process. If I happen to get denied, need to retain your services, how much do you charge? I charge, basically I use the standard fee contract that Social Security provides us, which is SSA 1693. I will put a copy of that in the notes, 1693. And basically it is, just copy that, copy the link. I'll put that in there so you can see exactly what it says. This is what I use. It basically provides for 25% of past due benefits, meaning the benefits that have accrued while you're waiting, with a cap. The cap right now is $7,200. In December, I believe it goes to $9,200. Very few cases are that high, but it is capped, so it's not unlimited. But it is right now $7,200, 25%, no fee unless you win. So, you know, that obviously we both have a stake. If I take a case, it's because I think it's viable. Obviously, you know, it's two and a half years of work. I'm only going to take cases I think that have a decent chance at winning. But yes, I get paid if I win 25% of past due benefits. Okay, the veteran, can they change what the doctor has wrote? I don't know that you can change it. I mean, you can certainly, you know, write the doctor a letter, an email saying this is incorrect. I tell my clients sometimes if there's something in the medical record that appears to be incorrect, then let me know that, and I can put that in, get a statement done, basically a statement you make that basically says the doctor is incorrect about this, and we can add that to the record. The judge can decide what to do with it. We can ask the judge to give the incorrect medical record less weight, but that is purely up to the judge. Okay. Well, the letter, yes, Guy, the letter, the favorable decision. It's really more of it's not really a letter. It's kind of a 15, 20-page document, but it will tell you what reasons the judge found you disabled for. But let me point this out. Going forward, if you have something new that is also going to contribute to your disability, make you unable to work, that would be something you'd want to develop if you were reviewed. You're not limited to just the things that got you on the first time. And if something gets better, that was the basis of your approval, but you have something else that's now taken its place and it's making you unable to work, then that would be something that you would discuss in a continuing disability review. Amanda says the vocational, I think you mean vocational witness, said you're not able to work, but SSI did not. And again, I'm just going to come back to it. Obviously, I haven't looked at your paperwork, but I know sometimes people will hear the vocational witness saying there are no jobs. Like for example, at every hearing, I'm going to ask the following questions. Mr. Vocational Witness, assume an individual will be off task for 15% of the day. Would that allow for competitive work? Answer is no. Mr. Vocational Witness, if our hypothetical person was likely to miss 2 or more days of work a month, would that be consistent with competitive work? No. So you hear that and you think, oh, we won. Well, those are questions I've asked, or the judge may have asked those questions. But you go back to hypothetical number 1 or 2, where the judge says, assume a light functional capacity, no climbing ladders, ropes, and scaffolds, no working at unprotected heights around dangerous equipment, dangerous moving machinery, no bending, kneeling, crouching, or crawling, frequent reaching with the left upper extremity, unlimited use of foot controls, and person would be off task 5% of the day. There will be jobs from that hypothetical. So remember, the judge is going to ask several hypotheticals. Don't just listen to the last one. Listen to all of them. And unfortunately, if the judge chooses, the first or second or third that got the responsive jobs, then you will have a problem because there will be an unfavorable decision coming your way. All right, Garrett has a fan club here, looks like. Big One says, hi, everybody. Hello, Big One. All the hypotheticals say no job, and she still denied you. Well, that would be grounds for appeal, because if every hypothetical was, basically said no jobs, then what you have is a judge substituting his or her vocational assessment with that of an expert. And they're not allowed to do that. That is reversible error. So that would be grounds for appeal. That would be worthwhile talking to an appellate lawyer about an appeal to the appeals council. Okay. And I put on these in the comments, but here's a couple of places you can get free residual functional capacity forms. Okay. All right. I'm not frozen anymore. Okay, it's buffering. Okay, that's back. Okay. All right. All right, Jarius. If a person has a case with vascular dementia, which is very progressive at age of 61, yes, you will. I think we're going to win. I think that's a good case, because vascular dementia obviously does not spontaneously, resolve itself. At 61, there's not going to be any transferable skills. Even though it's not an exertional problem, the grids won't apply, but there is something called the POMS, which talks about transferability of skills. And I think that, it's unlikely that at 61 there'd be any transferability of skills. My case today was a person over 60, and that was what the judge was focusing on, was there's no transferability of skills. Plus, unfortunately, vascular dementia is obviously going to create a lot of functional limitations. Astrofreak. Okay. My hearing is a week from tomorrow, but I'm hearing and learning so much I'm actually excited for. Yeah, again, I think you have to look at these hearings not as you're not on trial for anything. And I think this is a chance for you to tell the judge, what's going on with you. I always go into these cases with the idea that you don't want to be pursuing disability. You'd much rather be working. I would look up the judge, put the judge's name in. There are a lot of places where you can see, reviews about percentage of approval. And again, if you have a judge with a 55, 60% approval rate, that's a good sign. If it's a 30%, that's not as good of a sign. So, I wouldn't say take it lightly. This is not going to be a fun morning for you, but I think this is a chance to tell your story. And I think I would tell you, go ahead and, really think about how you're going to answer questions you're going to get. How long can you sit, stand, walk? How much can you lift, carry? Can you kneel, crouch, stoop, crawl? Things like that. Can you lift, overhead reaching? And you have to be able to also say in a very concise way why you feel you're not able to work. I call it having an elevator speech, so you want to make sure you do that. Okay. The field office called and said the medical was done and asked me about self-employment when I stopped working. If you did in 2007. So again, Jerry, if you have not worked since 2007, or if you've not been paying taxes since 2007, you're probably not going to be insured for SSDI. You can pursue SSI, but SSI has limits on assets and income or support. So you can have your SSI reduced if you're getting support from family and friends, things like that. So, that's a non-medical factor, whether you have enough credits or whether you're still working, things like that. So that's part of what they do. Jenny Joe says, I meet the listing at 1.15 and 100%, and preparing a beautiful letter for SSDI on your behalf to say why you meet the listing. That's great. If you can have a doctor who will go on record and basically talk about that you meet a listing and why in a narrative form, that's a really, really strong, strong bit of evidence to have. So that's great. That is great. Rick tells us that my hearing was in February. I'm still waiting for a decision. Even called the hearing office. They told you it's pending. I just got a decision from a case I tried in October of 23. So it's unusual it takes that long, but it can take a long time. So February, now is, we're 6 months later. That's starting to become a little bit unreasonable. And I think that, again, some judges just take forever. I remember there was a judge in Atlanta that would take routinely over a year to issue a decision. I just think that was just so cruel. People have been waiting all this time, that they're relying on this. And, the issues are pretty straightforward. Are you going to approve them or not? But why make them wait a year? But there's, and I think this one judge was kind of pushed out because he was actually a really nice guy, the ironic thing. But I mean, he was just taking way too long. And what we would do is we'd reach out to the regional chief judge. And I hate doing this because you don't want to get the judge upset at you. But like, look, Judge so-and-so has been, considering this case for the last 12 and a half months, 13 months. My client's suffering. Would you, well, all due respect, will you ask him to please go ahead and get the case decided one way or the other? Jenny Joe, you are very welcome, Jenny Joe. All right, Elias Miranda. Hello from New York. Question, I was granted medical for life through workers' comp. My left knee. Can I still file disability in my left knee when I retire? All right, this is a difficult question to answer without having a lot more information. Let me just tell you what the issues are. Is Medicare is very concerned about people, using Medicare to pay for medical treatment from a work injury. In other words, they don't want a person who's injured on the job to basically, foist the lifelong medical care onto Medicare when workers' comp should be paying for that. So in many states, I guess most states now, Medicare will demand something called a set-aside or a Medicare set-aside in a workers' comp settlement. Basically what that says is when you settle your comp case, and let's say you settle it for $100,000, Medicare may say, we want you to take $30,000 or $20,000 and set that aside as a special account. That is to be used for your medical treatment. And there's different agencies that figure out this Medicare set aside. And it's kind of a controversial thing because, it's sort of implied in the law, but let's just leave it at that. That basically a Medicare set aside is where Medicare wants you to take money that arose from your workers' comp injury and your settlement, and use that to pay for future medical care. And once you've used that up, you can then ask for Social Security or Medicare to cover it. Some of these settlements also say that you agree not to file for Social Security disability for 33 months, or something like that, some amount of time, so that, you will be, hopefully using up that Medicare set aside money. And, that way, if you come back in 2.5, 3 years, Medicare can look at it and say, oh, that's kind of a new injury. So anyway, it's kind of a legal fiction, but that's what they do. So long explanation to a simple question, and that is, if you have lifelong medical for your on your knee for your workers' comp, which is unusual that they would give you lifetime medical, the question is that going to create a problem with Medicare if you get approved for Social Security disability? And also, now when you retire, I think probably less so, but certainly for disability, it would be an issue. I would tell you that's probably a question that I would pose to your comp lawyer or maybe to an elder care lawyer, because these issues of Medicare set aside get very, very complicated, and it's just it's just one of these things where you just you've got to have somebody who really looks at all the facts to be able to know. Okay, YouTube user, I put it. You look, if you read up in the comments above, I put both the links up there, so they're there for you. And if you don't see them, just let me know and I'll post them again. I may post them again probably during the course of this. All right, so Christina says, congratulations, Guy, on your approval. Yes. Are you hiring an attorney at this time? I don't know. Am I hiring an attorney for, like, as an associate? No, I'm not hiring an associate at this point, if that's what you're asking. M. Williams, 55555. Have not been able to work since 2015. No diploma, seeing a doctor for migraines before COVID. All right, so if you haven't worked since 2015, then your insured status for SSDI will likely have run out around sometime in 2020. Normally, since you have to have 5 out of 10 years, if you stop working, that your insured status follows you for about 5 years, logically. So your insured status probably ran out in 2020. So that means if you want to file for disability now, you've got to prove with medical evidence that you became disabled prior to the date your insurance ran out, prior to sometime in 2020. Let's just pick a date. I mean, there's a specific date, but some date in 2020. And it's hard to do that because that's now 4 years ago. And so, and 55, if you're 55 now, you were 51 4 years ago. So again, different grid rules apply. The sedentary grid applies at that point. I think the other issue is, getting the records. Believe it or not, even 4 or 5 years, records disappear. I generally say if I have to go back a year or two, I'll do it. If I have to go back more than a couple of years, that starts to become problematic because it's hard to get the records. It's hard to convince a judge that, you were really unable to work 4 years ago, 5 years ago. So it's just hard to do because judges just, obviously the question they're going to ask is, what have you been waiting for? Why didn't you file? And again, rightly or wrongly, the assumption is if you didn't file, you must not have been disabled. So that's the issue you run into. So not impossible, but it's an uphill battle. All right, LaDonna Taylor says, I denied twice and now lawyers appealing it. They say I can do secondary work, so going to court to have a chance. Do you mean sedentary work? Is that maybe that's what you mean? Sit down type of work? Again, it depends on how old you are. Depends on what your medical condition is. If you were denied at initial and recon, you're going to get what they call a de novo or brand new hearing at your hearing. They're going to completely ignore what was done before. So you'll get a fair hearing with a judge who has much more discretion to approve your case. If you've had 2 prior unfavorables, that's a little more problematic. But yeah, you have a chance to win. It just really depends on what the evidence shows. Kamikaze says, your hearing is tomorrow. Well, Kamikaze, I would tell you that I wish you the best of luck, and I hope that this helps you prepare a little bit. Remember, you want to focus on the specific issues that prevent you from being reliable at a simple entry-level job. How is Parkinson's treated? A very good question. And I have a number of Parkinson's cases right now. And I'm usually successful with them. Parkinson's obviously is going to cause a number of issues. Most people know about the rigidity and the difficulty you might have walking or standing or lifting, things like that. You're unsteady in your feet. There can also be cognitive issues with it. There are treatments, the L-DOPA medications, and that can sometimes slow the symptoms, but usually it's progressive, and if you have it for a long period of time, the symptoms will eventually get to the point where you would not be very reliable at a job. And so what I usually look for is records that show the doctors that continue to increase the dosage of your medication, maybe changing medications because the medication they had you on was not working. If you have a neurologist, basically that can say that, the disease is progressing and maybe offer some thoughts about how it affects you functionally and, or cognitively, maybe a neuropsych evaluation to talk about how it affects you cognitively. But, generally speaking, if you're over 50, let's say, and you've got diagnosed Parkinson's for a number of years, over time, it's going to create symptoms that would be work preclusive. It may not preclude you from your daily activities in life. You may need more rest. Fatigue is a big issue. I've had people tell me headaches are an issue. So, I think that you hit a point fairly quickly in a Parkinson's case where the symptoms, medication side effects are going to be such that you would not be able to be reliable at a job. So I think they are usually pretty good cases. And obviously we all hope that medical science will come up with some, better drugs that will help people with Parkinson's maintain their functionality longer. But right now, it's still a very, very debilitating condition, unfortunately. Christina says, do not forget to share and subscribe. Yes, thank you very much. There should be like a subscribe button at the bottom of this, and there's a share. You can share it. Also, I'm going to put this up here. I have a place to, let's see here. You can, if you find this helpful, to drop me a quick review. You can do it on Google. Just type in Ginsberg Law Offices, you'll find us, or look at the link there. You can go to avvo.com. That's another place where I look for reviews. Yelp has them. There's any number of places, and I've got, if you just type in my name, Jonathan Ginsberg, you can see places you could leave a review. But if you wouldn't mind, if you find this useful, please, the videos and the live stream useful, please, I would really appreciate that, because it does help me greatly when I'm building my practice. So thank you. And thank you, Christina, for bringing that up. All right, LTLT. What if I'm applying for both Social Security income and Social Security disability, not worked past since 2014? If you're talking about retirement Social Security, they're going to look at lifetime earnings. So that would be an automatic. If you're talking about SSI, or supplemental security income, that would be if you don't have the earnings records. So many times when people, let's say, have not worked since 2014, that means your date last insured is 2019 at some point. So you want to, first of all, make sure your onset date is before sometime in 2019. Before the date last insured, and you can find out from Social Security what your date last insured is. So if you haven't already done that, if you've already filed, you want to make sure that you change the onset date to some date, again, 2018, early 2019. That way you're in the SSDI world. Doesn't mean you're going to win, but at least you have a chance. And then you have to argue that you became disabled before your date last insured of sometime in 2019. Probably, I'm just guessing, but based on 2014 plus 5 years, that's where it came from. If you don't have enough credits, or if the judge found you disabled in 2023 or 22, it would be an SSI only case. You only get SSI as of the date you apply. So if you applied in February of 24, that's the earliest date you're going to get SSI. You can't go back in time. Whereas SSDI, you can go back a year from the date you applied. So, yeah, I think that if you file for both, then that kind of gives you a chance. If it turns out that you are SSDI, you don't have credits for it. All right, Andrew Gallegos. Thanks for your help. I sent an inquiry to the website. Looking forward to. Okay, very good. Thank you, Andrew. I will make sure to respond to that. Thank you very much for doing so. LTLT has many mental issues. This is the person filing for both SSDI and SSI, I think. Was type 1 diabetic when you turned 34 years old, got pregnant, had a hold of the job, just found a tumor on my back. Yeah, those are significant things. And, again, if you're saying you became disabled in 2019, obviously the diabetes would be something you'd look at to see how that affected you in 2019. The tumor on your back is recent, so that's only going to help the SSI part. The mental issues may go back if you've got mental health treatment going back to, 2017, 18, 19, that sort of thing. That would make it possible to win SSDI. So I hope that does work for you. All right, Big One says, I have CDR anxiety. It's not due till next year. It was approved in 22. Again, Big One, don't assume you're going to have a CDR. CDR stands for Continuing Disability Review. You might not. They suspended all of them for the rest of this year because they're trying to catch up the backlog. Is it possible they could suspend them for part of next year? That's possible. Is it possible that somebody looks at it and says, we did a review without even letting you know we did a review and there's no problem and you're going to continue to get benefits? So, don't freak out about it because you may not be reviewed. And if you are reviewed, as long as you're going to the doctor and nothing has really changed substantially, then you should be in pretty good shape. DSS Fresno helped me turn my claim. All right, so I'm not sure if you mean the Disability Social Security office in Fresno helped you turn your claim. Again, they're not supposed to give you advice. If they helped you with some of the technical part, that's fine. At the end of the day, though, you have to be your own advocate, you or your attorney. Don't assume Social Security is going to develop your record. You're going to have to develop your own record, make sure you get the medical records to them, or make sure they have the information to get them. And they're going to do what they're going to do, but you have to push. You have to be an aggressive advocate for yourself. Kamikaze, does crypto count as an asset? Yes, crypto does count as an asset. Obviously, it's going to have varying value depending on what you have. I hope you have like 1,000 Bitcoin. That would be nice. But yeah, if you've got crypto, there's a fair market value, and that would be an asset, which could be an issue in an SSI case. Okay, Peter says, Peter Protentis, my case was remanded back to Social Security from the federal judge. What's the next step and chance of winning? It'll go to another hearing. It may go to the same judge who denied you. And, it really depends on what the district court said in terms of the instructions to the judge. They may tell the judge, you screwed up the way you analyzed it, do a better job. Some judges don't like it when they get slapped on the wrist and get remanded, and they'll be more likely to approve a case. I had a situation with a judge that, denies a lot of cases. I appealed them, went to federal court, we won, came back, and unhappily he granted the case. So, some judges just don't like the look. Other judges don't care. They're like, I'm going to do what I'm going to do. District court, blank you. So it just depends. But I think normally if the district court sent it back, they're kind of sending a message to the judge that, hey, you need to do a little better job, and hint, hint, go ahead and approve this person. They've waited a long time. Okay, the issue was 7 before I stopped working. Again, Jerry, without having all the information in front of me, they obviously were asking you, if you stopped working in 2020, then you shouldn't have a problem with insured status. Sometimes when people are self-employed, which I think you were, then they want to know, are you still doing that? Are you still involved in the business? Because again, it kind of looks like, sometimes people continue to receive earnings under their Social Security number because they let their son or their daughter or a relative or a friend run the business, but it's still coming into their name, or they may still be partially involved. Again, the presumption is you have your own business, that you're going to, you may find a way to sort of do it, kind of work under the table under somebody else, let somebody else do the, get the credit for it, but you're still doing it, getting paid cash. I mean, again, they're suspicious people at Social Security. So that's kind of what they're getting at. I suspect that you want to see what the reality is. And when you're self-employed, there are opportunities to, play a little fast and loose with the rules, as what Social Security thinks. I'm not saying people do that, but I suspect some do, and that's what their concerns are. Okay, Teresa. this is very common. She received 2 packets. One was the adult function report, due back the next day. The second was the work history report, which was received the day after it was due. I got it back to them. Normally when they give you a deadline, that's kind of a soft deadline. You figure a week to 10 days, get it back. But, when I get that, when that sort of thing happens to me, I just, I'll fax a letter to the adjudicator saying, we just got this. So it's going to be, 10 business days before you get it back. And I've never had a problem with that. So I just would let them know. Now I have a case right now where my client was denied. We never got notice of it. And it's been more than 60 days. So I'm going to file good cause because we never got the notice of it. And the reason I even know is because there's a service I subscribe to that tracks all of my cases. And it, I don't even know where they get this from, but it can tell when, a case has, I do know where they get it from. They've changed a few things at the Electronic Records Express, but it tells me that the case is closed. And it shows up that the case was closed, back in May, and we never got notice of it. And so we're going to have to file and get the case reopened under a good cause. But to Teresa's point, this does happen sometimes, but again, those deadlines tend to be soft deadlines. Calvin says, my case is in step 3 of the DDS process, DDS being Disability Determination Services, 52 years old with spondylolisthesis in the lumbar spine, truck driver, high school education. Doctor says sedentary work only. What may happen at step 3? Well, step 3 is, if you're talking about the sequential evaluation process, which is the way Social Security technically looks at cases. Step 1 is, are you working? Step 2 is, your impairment severe? Step 3 is, do you meet a listing? Step 4 would be, do you have, can you return to past work? Step 5, can you do any other work? So if you're at step 3 of the sequential process, they're going to say, do you meet a listing? You don't, because if you can do sedentary work, you don't meet a listing. You meet maybe a grid rule, but not a listing. If you're looking at the steps they put on these online, meters that tell you where you are in the process, I would take that with a grain of salt. Again, the typical time frame in a Title II disability case is going to be, anywhere from 6 to 12 months, or maybe more accurately 9 to 12 months. So, I don't know how long it's been, Calvin, but it's my guess would be, you're probably, someplace in that process, but whatever, if they give you your 53% done or you're at step 3, ignore it. It doesn't mean anything. But I think that, again, if you've got a doctor saying sedentary work, then I think the grid rule would apply here. And let's take a look at the grid rules. So I'll show you exactly which one I think would apply. Let's share the screen here. Okay, so I hope you can see that. This is the grid rule. So if Calvin is 52 years old, living in a sedentary work, he's going to be, and he's a truck driver, so he's got skilled. So 201.14 says 50 to 54. Well, he's 52. High school grad or more, we don't know that, but let's assume he is, but does not have skills that provide for direct entry into skilled work. If you've been a truck driver, that's not going to provide skills that go into skilled work, and his past work is semi-skilled with skills not transferable, he would be disabled. That's how the grid rules work. So you can see that, they're going to ask about transferability of skills, your age, your education, and your past work. And so that's really how the grids work. So I think 201.14 would be, in fact, what I would tell you, Calvin, is, reach out to the adjudicator and say, please review my case under grid rule 201.14, because I'm between 50 and 54. I'm a high school grad or more, or a high school grad. My work as a truck driver is either skilled or semi-skilled. We can look that up. Look at occupationalinfo.org and look it up under the DOT, but it's either skilled or semi-skilled. But I don't have any transferable skills because a truck driving job is very physical. There's no skills that transfer to a sedentary job base, a sit-down type of job as a truck driver. Therefore, I meet the grid rules. So please approve me under 201.14. That's what I would do. And I think you got a good case. Okay. So I hope everybody understands how the grids work. That's how it does. Okay. So So Teresa said she got it back pretty quickly, which is good. Rick has a very good question. If you win your case, can you keep your Medicaid? Medicare does not cover much. Not only does Medicare not cover much, but you have to wait 2 years to get it. In a disability case, if you're approved, there's a 5-month waiting period. So they don't pay you the first 5 full months of disability. Then you have to wait 2 years for the date of first payment. So you take the 5-year waiting period, the first month where you become eligible for payments, add 24 months to that, that's when you get Medicare. The problem is Medicaid is income-based. It's a resource-based program. So they'll probably cancel your Medicaid, but you won't have Medicare. And you're going to have nothing, no source of insurance for 2 years, around. Kind of unfair, but that's what they do. Then they do a CDR on you and say, we haven't gone to the doctor. Well, I can't go to the doctor. I have no insurance. I'm not going to give you an answer. It's just ridiculous. But that's the problem. Okay. Penny says, can you get your disability back payment early? Not to my knowledge. I mean, you can maybe talk to your congressperson and say, please write a letter to get this expedited so I can, because I need the money. But otherwise, it's going to just be, it's going to be a month, 2 months, 3 months, something like that. All right, John, step 3, the initial application. Again, I don't know what that step means because it doesn't really mean a whole lot. It's just they're just processing it and all that other stuff they're just telling you. Hearing office says the judge I saw is leaving. Someone else issued a decision. The judge previously said to me a listing. Skip the VE office. Everything should stay the same. Yeah, I've had situations, Lewis, where we have a case that went really, really well. The judge quits and they schedule another hearing. So don't be surprised if that happens. I've also had situations where it was a clear case winner. A different judge wrote the decision and everything was fine. So hopefully that will be the case for you. But don't be shocked if you get another hearing. Don't be shocked. There's no, again, you asked about the stage. The stages don't mean anything. It's just a number. They just make it up. I have to put it that way, but there's no definitive, there's no required there's nothing that says stage 3 has to be finished in 4 months. It's basically at initial and recon, you're looking at anywhere from 6 months to a year. That's just what it is. Okay, so Ryan kind of filled in what I talked about with Rick Torres, and that is if you're receiving SSI, you get Medicaid. If you're only receiving SSDI, you won't get Medicaid. But if assuming your SSDI is more than your SSI, which typically it is, you're not going to get SSI because it offsets. You don't get both of them together. You get the highest one, which is typically SSDI. So most of the time, not always, most of the time, when somebody gets approved for SSDI, if they were getting SSI or they had Medicaid, they lose the Medicaid, unfortunately. Okay. Suki Glass. I have schizoaffective bipolar. Got approved. I'll get reevaluated. If you have a 7-year review, Suki, you're not going to get reviewed. As simple as that. They're just, they say 7 years, but my experience is if they say 7 years, it really means never. 3 years, 1 year, they're going to review you. 5 years, maybe they review you in 4 or 5 years. 7 years, they almost never do. And if they do, you're not going to get, my guess is that you, unless you've gotten substantially better or you've gone back to work, I don't think that's going to be a problem for you. So I would not sweat that too much. KR, I applied for SSDI a year ago, a veteran, present at step 3 or 5 in the review process. What does the step mean? Again, nothing. The being 100% veteran disabled means your case goes to the front of the line. So you would get a faster review. But again, if the average is 6 to 10 or 6 to 12 months, maybe you're at 8 months. But step 3, that just doesn't mean anything. Just doesn't. All right, Garrett's remind me to put this back over here, so I'll go ahead and change the. Actually, I'm going to put this to the functional capacity. Somebody asked about that. Let me put that up for a couple minutes, and then I'll take it down. But that's one of the places you can get there. Okay. Let's see. Okay. When I switch screens, it sometimes will lose my place here. What about bone-on-bone knee issues at the age of 57? Well, I think, Lulu, then if you got bone-on-bone, that's going to mean you're not going to be able to do light work. Standing and walking 6 out of 8 hours means you're limited to sedentary work. That means that you meet the grid, assuming you don't have transferable skills. So let's take a look at that one, and I'll show you why. So Lulu is 57. Let's assume she is a high school graduate or more, and she does not have skills that transfer to skilled work, no transferable skills. Under 202.06, one of my favorite grid rules, she's disabled. She's limited to light work or less. If she's limited to sedentary work, and she's age 55, and she's a high school grad or more, no direct entry into skilled work, she's disabled. So, it's same sort of thing, either 201.06 or 202.06, bone-on-bone knee issues, assuming that there's objective testing showing that your knee is truly bone-on-bone, and you have, you're in pain, you're on pain meds, the doctor is giving you injections, things like that. You may be a candidate for knee replacement. That would be a good case, I think. I think knees, I always like knee cases because you can't really do much moving around if you have bad knees. Walking is a problem, sitting is a problem, standing is a problem, lifting and bending, kneeling, all that's a problem. So not much you really can do. Let me go ahead and change the banner here to show the free case evaluation there. Okay. And now let's go to Autobot. Wow, he's working on coming back from being paralyzed from the neck down, had to go through emergency surgery, took out facet joints, replaced with 6 screws and rods. I think, on its face, that tells me that's a pretty strong case, assuming you were unable to function for at least 12 consecutive months, which I'm guessing you were. Hopefully you start to feel better. Now, again, this may be one of these crazy cases where you had a terribly severe medical problem and the surgeries were successful, and now you're able to function again. So maybe, it becomes a closed period, or maybe they terminate you at some point, and terminate you from disability at some point. But I would say that level of impairment would tell me that the default would be that you should be found disabled. Kevin Tipton, 100% vet, applied, final step of a hearing with an allergy September 27th. So you apply. So you're getting a faster, believe it or not, yours is faster than a lot of people. You applied in May of 23, you get a hearing in September of 27. The 100% means nothing. Believe it or not, if it wasn't 100%, you'd be at May of 25. So it does mean a little bit, but that one. Big one was the concern about the continuing disability reviews. Okay. Chrissy's Coven, the RSD, or chronic regional pain syndrome, has spread to all limbs in 9 years. 2 car and 1 ATV accident with chronic back pain. The judge did not agree. RSD, or CRPS, is a pain syndrome. And just for those who don't know, Chrissy, I'm sure knows all about this. But basically what it does is that if you have RSD, which stands for reflex sympathetic dystrophy, or CRPS, chronic regional pain syndrome, you have pain that is in excess of what the objective evidence shows. You may have an MRI that shows mild disc bulges, or you may have a sprain in your wrist, but the pain level you have is off the charts. It's just because your body somehow is having a reaction to the trauma, and it results in this incredible pain. And it's hard to really pin down because there's not really a lot of objective evidence for CRPS or RSD. So it depends on whether the doctor believes you or if the judge believes you. And so, like other invisible illnesses, you have a situation where the judge didn't buy it. The judge is saying, well, the MRI looks fine. The x-rays look fine. The CT looks fine. There's no reason you should be in this pain. I don't believe you're in this pain. But in fact, you are in pain. And so you almost needed a CRPS specialist to, put you through a battery of tests and show that, in fact, this is legit in your case, and your level of pain is truly debilitating. I know it's fairly frustrating, but those cases are really hard because there's no objective evidence, or the objective evidence is not consistent with the complaints you have. I'm sure your unfavorable decision said that I believe the claimant's in pain, but not at the level, it's inconsistent with the medical evidence. And that's why they turned you down. Forgot to mention close to 63 with Parkinson's. I think this is a person with Parkinson's. Yeah, at 63, then that's going to make it even more likely you're going to get approved, because again, that's you're approaching retirement age there, and so it's less and less likely anybody would hire you, and Social Security recognizes that. Sam the man, application. Pardon me. Was denied after a CE consultative evaluation. Doctor visit took less than 10 minutes. You refused to look at the MRI reports for neck and lumbar hernia disc. The CE killed your case. Perhaps if your application was denied, that means you're talking about initial application. And at the administrative level, initial and recon, to win a musculoskeletal case is really, really hard. You almost need to be at listing level or meet a grid rule. And I don't know how old you are, but assuming you're under 50, unless you meet a listing, which you probably don't because almost nobody does, you're going to get denied, but you should appeal it. And if you've got a herniated disc, a lumbar disc, that's going to cause a lot of pain. And so you're part of the way there because, you have a medical condition that is reasonably likely to cause significant pain limitation. If you're 35, tough. It's difficult. If you're 55, it's a much, much stronger case. So that's what I would say about that. Okay. KY, Kentucky, has not visited my specialist for 6 years. And then because of fatigue, I sleep and rest all day. I sent you a letter asking for medical history. Yeah, that's a little problematic because, in a C, if they're asking for updated records, the assumption they make, Social Security makes, is you're not going to the doctor, you must not be disabled. Not right, not fair, but that's what they sometimes will do. So, I would tell you if you can get to a doctor, that would be very helpful. And you may have to build your record now. And if, again, I realize you're fatigued, but if you're getting medication refills, at least you're doing televisit. I think you have to make some effort to show you're seeking some sort of treatment, whether it's a telemedicine visit once a year, whether you go in. It's a hard argument to say, I'm too fatigued to go to the doctor at any time in the last 6 years. That's going to be a tough argument. So, it doesn't mean you're going to get terminated, benefits terminated, but I think you're going to have potentially some problem. Okay, Chrissy said, I think we were talking about the RSD, and yeah, I realize this is the problem. I mean, and you're talking about, the problem that a lot of people have is they can't afford to go to the doctor. They can't afford to see a specialist. But, in an RSD case, a CRPS case, it's because it's not something you can image. You can't take an MRI of CRPS. They put the burden on you to get them the medical record or medical evidence they need to approve your case. So, you simply going in there and saying, I'm in terrible pain, even though the medical evidence doesn't show it, that's why they denied you. And it's not fair. I'm not saying it's right or fair, but this is just the situation that you're in and we're all in, because, you can't afford to go to the doctor, but then they deny you because you couldn't go to the doctor. And again, they get away with that because they can say, well, we sent you to a consultative evaluation. That satisfies our burden to develop the record. No, it doesn't, but that's what they say. And so it leaves folks like Chrissy really in a bad place. Do you get penalized early for drawing Social Security while waiting for disability approval? No. A lot of people do it. They go ahead and file for disability for retirement. They file for retirement and they file for disability. They get the retirement money coming in. It's about 75% of full retirement. If they win disability, it gets bumped up to 100%. So it's no penalized. You get penalized in the sense you get less out of retirement because you're taking early retirement, some percentage, 75, 80% of what you get at full. But yeah, go ahead and pursue disability because you're older now. Obviously, that's number one. And number two is if you win, then you are going to be getting a lot more money or significantly more money, maybe $500, $600 more a month than you were when you're getting early. So go for it. Her doctors are 88 years old. That's impressive right there. This is the person I think with who's had the fatigue. Having trouble finding new doctors, tested a 2-day CPET. Again, there's no definitive answer as to what you should do. I think, getting to a doctor, somebody who is currently in practice, if your doctor at 88 is not still in practice, you just got to show something. And I'm not doubting what you're saying that, terrible fatigue, but it's just that the optics aren't good when you say I haven't been able to go to the doctor in 6 years. So, the CPET, I'm not sure what that is. I guess that's a PET scan of some type. So yeah, if you've got that, that's evidence, and that certainly would be something you would provide to them. But it would be helpful to have more kind of ongoing, even annual visits with a doctor to kind of monitor your condition. Autobot, I have severe spinal stenosis with cervical myelopathy and spastic gait. Gait, G-A-I-T, not gait. That's what it means. Walking is what he means. That's a significant problem. And so I think that would be something that, your symptoms of pain, of limitation of movement, difficulty, climbing ladders, ropes, and scaffolds, balance, things like that. Those are consistent with this, this diagnosis. And so that lends itself to an approval. Truba. Can the SSI take out the SGA due to the way economy is to avoid financial restrictions? No, they will not do that. They look at SGA and say, if you're over SGA, which is like $18,000 a year, people, this is not a lot of money. But if you're over SGA, then you are, in fact, I'll show you the SGA table here so you can see it for yourself. Not that I'm sure you believe me, but let's just take a look here. Let me present. And I have a page on my website, the for socialsecuritydisability.com. I've got a page under the FAQ. I'll just show you that. It's called SSA's Confusing and Inconsistent Table of Earnings, a table of numbers. So I put this in here because you have the SGA numbers, you got the trial work period numbers, and you have the amount that you need to earn a credit, and it's all different. But the SGA numbers, which I have in here, here's the SGA table, there's a link there. Let's go over here. You will see that for 2024, if you're not blind, if you're blind, it's higher. But if you're not blind, for 2022, it was $1,350. 23 is $1,470. 24, it's $1,550. They're not going to waive that. Just not. So that's just how they look at it. They assume if you're earning $1,550 a month, you're not disabled. Now realize if you are working, if you apply and you're working part-time and you have 1 month or 2 months where you're over SGA, that's not going to disqualify you. But once you get to 3, 4, 5, 6 months over SGA, especially continuous, that's going to make it more difficult to win. Okay. The KY is the person who talked about not being able to go to the doctor. Yeah, they could. I mean, I'm not going to lie to you. They could open a review. Obviously, if they send you a form, fill it back out and put on there why you were not able to go to the doctor. But yeah, they could. They very well could. I hope they don't, but they could. Rebecca with a K, Powers. How can I qualify for disability in ADHD, PTSD, insomnia, and depression? Been denied, not able to work, barely keep up with doctor's appointments. I will tell you, Rebecca, ADHD is a really, really hard argument to make for disability. I don't think I've ever won an ADHD case. It can make other things worse, but it's not on its own going to be disabling. PTSD and insomnia and depression, they've got to be pretty severe. And by severe, I mean inpatient hospitalizations, multiple failed medication trials, suicide attempts, things like that. It's got to be beyond, mild to moderate. It's got to be severe where it interferes with your daily life. And you got to have evidence to that effect. So you've got an uphill battle. I will just tell you that, unfortunately, with ADHD, really not doing much of anything. And then the other things, the insomnia, PTSD, depression, you've got to have significant evidence. And it's just hard to get that. because doctors don't necessarily want to go on record to do that. Mr. JPF, can I file for SSD? I was injured February of 23, found disabled by the city and forced to retire. We paid for approximately 6-9 months. Can I file now? Well, assuming that there's no workers' comp case here, that's if you have one, has it been settled? And by settled, have they issued a settlement that has some language in it that says that the lump sum represents your lifetime earnings, payment over your lifetime? Different issue, but I just mentioned that. If you were getting paid for the next 6 to 9 months and it's workers' comp, that's, you can apply, but you're not going to get paid for that period of time where you're getting workers' comp. If you're getting a regular salary, kind of like accrued, like a severance package, I believe that would not count. But I'm not 100% certain, but I believe that would not count against you. So I think in that situation, you could fall, as long as you're not going into work. Excuse me. As long as you're not going into work, I think you're fine. I think where you're into trouble is when you go into work, and if there's workers' compensation. There's another time when that's a problem. Using next month as a trial work period. Okay, yeah, that's continuation. Can you, if you are getting paid like a salary, you may not have to, because again, if you're not working, the only time the trial work period is if you're actually going into work. But if you're not going into work, it's unearned income. It's basically like passive income. So not an issue. Okay. Steph S. Confused on the grid rules. Lisa told me I have to prove I'm disabled first and then can address the grid rules and recon 12 months applied, 51 failed cervical fusion. No, you don't have to prove you're disabled. Well, again, being disabled is a legal determination, but the grid rules, basically you have to show, you have to have a doctor have evidence to show what your functional capacity is. So if you're 51, you're going to need to show that you are limited to sedentary work. Once you show you're limited to sedentary work, then you ask the other questions about transferability of skills, and and your past work, unskilled, and if you're unskilled or no transferable skills, then you would apply the grid rules. But you don't have to be found disabled first. You have to be found that your functional capacity, a legal determination, is sedentary, which means sitting, standing and walking no more than 2 hours a day, lifting no more than 5 pounds occasionally, 5 pounds frequently, 10 pounds occasionally. That's step one of the grids. Then the next step would be to ask the transferable skills question there. Look at gridrules.net. I think I've got even a little thing in here. Okay, just look at gridrules.net, Steph, and you will see some examples of how they actually work. Okay. About how long does it take the appeals council to make a decision? Do they pay if it takes 2 years? Okay, the appeals council is going to take 6, 8, 10 months to make a decision. They typically don't actually award benefits. They remand the case back to a judge for another hearing with guidance. So they don't actually issue a favorable decision. They can. I've never had it happen, but they could. But it's not likely to happen. And if it adds another 2 years to the process, yes, your back benefits continue to accrue. I've had cases that we've appealed to federal court, after going to the appeals council 4 or 5 years. My client's getting a check from the government for $100,000. So yeah, it can really add up. How early can one apply for disability? You can apply at 34. The problem is you're going to have a really hard time winning. So you can apply at age 25. Doesn't matter. You have to have something really significant. I think I've used this scale before. If you're 34, the level of evidence needs to be up here. If you're 55, maybe you're right here. So it's just a lot more evidence, a lot stronger evidence. It's just more difficult because realize the Social Security is running out of money. The trust fund's running out of money. Congress is putting a lot of pressure on Social Security to not approve people in their 20s and 30s because they don't want to have a drain on that fund for the next 30 or 40 years. So it's just really hard. It's really hard at 34. It's going to be hard to find a lawyer, quite frankly, because unless you've got something incredibly severe, you're going to have a hard time finding a lawyer to take it because we only get paid if we win. And the odds of winning at 34, regretfully, are just not very good. T-Cash. SSDI said it was approved in April, waiting for non-medical approval. It's a paper file sitting on a desk. They mean a digital. It's a digital file. Well, usually it's a digital file. It can be a paper file. Hopefully it's not. Most of them are digital now. But yeah, it's sitting on somebody's desk, either physically or, symbolically, just because they've got to go through it. Rebecca, if you have a child with disability, try to cut theirs if you win yours. If your child's getting SSI, I don't know. I think that there could be an offset, but I don't deal with child cases very much, so I'm really not the right person to ask. Greg Brinkley might know. I had him on here a few weeks ago, but you can email Greg at Greg at Brinkley, BRINKLEY.org, and ask him that question. I just don't know, and I don't want to guess. Yes, Deb Lindley is correct that CRPS or RSD, it's hard to win with those. Very hard to win. Kevin Tipton. Yes, you can apply anytime after you become disabled, or again, disabled is a legal term. So anytime after you are not able to work reliably 8 hours a day, 5 days a week, or earn more than $1,550 a month, 2024. You can apply at any point. But then you will be waiting, and you could be waiting 8 or 9 months. You could be waiting 2 or 3 years. So yeah, that's correct. But yes, Kevin. All right, my friend Mark, happy anniversary. You got 1 year recon today. I hear you, Mark. I know it's crazy. It is crazy. I can't remember what office yours is out of, but some of them are just really, really ridiculous. But a year is way too long. I would agree. Princess Brianna, got my notice of award a couple of days ago from SSI. Got approved without a lawyer and appealed. And this is very lucky. Yes, good for you. You know what? It doesn't happen a lot, but it does happen. And I put all those videos out there so people can, if they want to do it themselves, they can. So yeah, good for you. I'm pleased to hear that. I hope that that some of the information I have out here was helpful, and some other stuff online was helpful as well. Just got approved. Medical administrator deducting from Medicare. All right, so this is a question about Medicare, and they deduct it. I don't really deal with that. You might want to check with my buddy Cal Hero, Hero. His website is the Medicare Mall. Let me just make sure I've got this correct. MedicareMall.com. Reach out to Cal, C-A-L. Reach out to Cal. He's out of Texas, and he does a lot of work with people who are on disability, who are getting are eligible for Medicare, and he can help you come up with the right Medicare program that is the least expensive. And he and I have become kind of friendly over the years. We had dinner together at a convention not too long ago, and we chat periodically. He's a really sharp guy, and he's honest. And I've had a lot of people I've told to go talk to him about Medicare issues. He's very generous with his time. But I would talk to Cal, and I will let me put a link here to the Medicare Mall in the comments. But yeah, check that out if you're interested in Medicare issues. Again, his name is Cal, C-A-L, Hero, just like a hero. But he's a good guy, and he would be a good person to talk about that. Wendy and Ricky, I was denied in June of 23 by age. This shotgun me through the process. Yeah, if it's going quickly, that's usually a pretty good sign. Yeah, that would be a pretty good sign. I don't know how old you are now, but that's a pretty good sign. Q, I think Q is the 34-year-old. I think so. Yes, you are 34. Okay, from Pacific Islands, unemployed my whole life, living off the land. You would have to pursue SSI. You don't have, unfortunately, Q, you don't have any credits unless you consider you're a disabled adult child, but that's a whole different issue. But assuming you're pursuing it on your own, SSI would be what you got to go for. And farming, even if you're not making money, could be considered SGA. So that's going to be a complicated issue. Lulu, thank you. You're welcome, Lulu. The truth is amazing. I just got approved for SSI and SSDI. I'm medical Cal. The deducting ones. Okay, I think that's the one where you talk to Cal Hero about that. On my consultative exam, the report says ability to work with the public moderate to marked. What does marked mean? Bad. Marked means it's really bad. So, basically very, very, very limited, not precluded, but very limited. So marked limitations are ones that it's really hard to do anything with it. So that helps your case is the bottom line. Phantom swords, platinum swords. Stenosis, radiculopathy, and impingement, sciatica, 9 months. Again, you should get approved, but because it's musculoskeletal, you got to meet that listing. They make the listing almost impossible to meet. So, I hate to tell you this, you're probably going to get denied. Not absolutely, but you're probably going to get denied. You should appeal it. You'll win at a hearing. I mean, you're going to win at a hearing. Again, I don't know how old you are. I shouldn't say you're definitely going to win, but if you're over 50, I think your chances of winning are really, really strong. But you're probably going to get denied because of the listing being so difficult. Okay, here. Robert, where have you been, Robert? Hello. How are you doing? I can't believe that SSI deals with paper files. They really have gone paperless. There are a few legacy files. They call them paper cases. There are a few out there. It's probably 3-4%. So most of the cases are not paper files. Very, very few are. If you brought them a bunch of records, they're going to have to scan them. That takes time. So if you're going to submit records, it's better to submit them electronically. I submitted through the Electronic Records Express, but if you bring them a box of paper, they're going to have to scan it. So that's going to take more time. But paper files are kind of on their way out. I started doing this, it was all paper. So Kevin is correct. I would agree with everything he says. Okay, Clayton Thompson, 52 years old, 4 strokes, heart attack with a stent, diabetes, high blood pressure, congestive heart failure, put in for benefits. I think they're pretty good. I mean, you had 4 strokes, heart attack with a stent. I think you could make a pretty compelling argument that there's not a lot of stuff you could do. I mean, I think that's a strong case. I'd most likely take that case because it's and again, I would wait to see if you get approved before you hire an attorney. But I think that's a pretty solid case at your age. Gator. Okay, I'm in the Florida Gators. I'm in Georgia, so Bulldog fan. Although I went to Tulane, so we had the Green Wave, which is not much of a football team. Although they periodically have a good year. They finished number 20 a couple of years ago or a year ago. But the Bulldogs and the Gators have a long-time rivalry. But I'll still answer Gator's question, just because I'm that kind of guy. Gator is 48 with cervical and lumbar degenerative disc disease and arthritis of the back, bone and bone. No, you don't meet a grid because you're not over 50. You got to be over 50. I mean, except for like one rare circumstance, 99.5% of the grid rules, you have to be over 50. So you won't meet a grid rule. You have to go functional capacity. Okay, well, this is a Medicare question again. Okay, yeah, I mean, at 34, yeah, I think that's about right. You have to be a hair away from death. Off the top of my head, I do not, I cannot think of anybody off the top of my head. I think I would just you have to do some research, Google it, look online, see who's writing the papers, but nobody comes to mind, unfortunately. And affordably, I know it's hard with these specialists. Go to the doctor, can't even be doctors. Yeah, sometimes doctors don't want to get involved in disability cases, and it can be challenging. It can be a challenge. James McDougall, how does Social Security look at circadian rhythm disorder, specifically cited non-24 disorder, freedom of sleep disturbing post-study schedule? Interesting, James. I've never had a case like that. I've had, some vascular cases, which is not really the same thing, but, it's kind of unusual. I think that would be a case where you'd have to really educate the judge about the severity of the problem. I've had a few, rare disease cases where you submit research papers to show what this condition is. I think if you have a specialist that would be willing to help educate the judge, you got a shot. And I said chronic migraines and mood instability, almost got arrested. Again, I think, if you're getting treatment for the migraines, that can help. The mood instability, maybe there's some psychological stuff going on there. But I think if it's the circadian rhythm, I think you need to really get a specialist and really, educate the judge. And again, that's, if you had an attorney, that's what an attorney would do for a rare disease like that. Okay, we keep getting this Medicare question. So again, Cal Hero would be the person to call. Maybe a crazy question. Maybe it is. Maybe it did. We'll see. If a person is completely unable to go to the doctor because of severe neuropathy, pain, unable to stand, where do you turn? I think you have to try to get a video appointment, a virtual appointment. It's hard. It's really hard. But, I think you have to show Social Security judges, I've had judges tell me they really don't like people I hate to use given up, but they've sort of decided they just can't. And, you got to have evidence. I mean, the problem is, in a disability case, it's hard to just sort of say, well, I can't get to the doctor, therefore, pay me. You got to be an advocate. You have to find a way to make it happen. I hate to put it that way. But, maybe you have somebody, rent a van and take you there in a wheelchair. Maybe you find a doctor who's willing to do a house call, if that still exists. Maybe you do a video appointment, but you got to do something. You can't just not go. I hate to tell you this, but you just can't not go, because if you don't go to the doctor, they look at it and say, not going to the doctor is the same thing as not being disabled. Okay, thank you, American Black Holocaust survivors. Thank you very much. I appreciate your vote of confidence. I really do. Thank you. That's much appreciated. This is, again, the specialist, 1,500. This is a problem. This is a major problem. I mean, if you need to see a specialist and it costs you $1,500 a pop, that's gonna make it really hard. That's gonna make it really, really hard. There is no answer to that. It's just, you're gonna have to get enough evidence together where it's going to be convincing, and it may require a few of those visits at that cost. Is that your basement? Yes, that is my basement. What you see right there, that is a video light called a pancake light, and that's what I use when I do my videos. That is the edge of my, if I can point there, that is my video camera setup, because when I record the videos, I use the screen as a background, and that is a file cabinet that's got a bunch of camera equipment on it, and then that is the door to the rest of my basement. I've got my little man cave down here that my wife, gives me a really dirty look when she walks in here, because it's perfect for me. It's got all kind of stuff in here, all kind of electronics and things like that. It's ideal. My wife does not find it very amusing, but I gave her a warning. So, yeah. 2-day cardiopulmonary exertion test. I mean, I know these are expensive, very, very. I think that powder puff, that's exactly right. That's exactly right. Get a virtual appointment, a video appointment. Okay, how is it determined? The grid rules are, it's not something they can choose to ignore. I mean, if you're over 50 or over 55, they've got to look at them if you've got an exertional impairment. So part of the judge's analysis, I told you that a judge, when you appeal to the appeals council or district court, you have to say the judge made an error of analysis. So if you have a person with a physical impairment, significant physical impairment, who's 55 years old, and they're denied, and the judge did not look at the grid rules, that's grounds for appeal. That's exactly what a grounds for appeal would be. That you have a person over 55 with 3 herniated discs, the judge has an obligation to look at the grid rules. And so it's not voluntary. They've got to do it. But they would have to make a finding that there's no exertional limitations, therefore the grids don't apply. Or they make a finding that, you are 52 and you can do light work, therefore the grids do not apply. They still have to mention them. So yeah, it's not up to the judge. The judge can decide whether you have transferable skills and things like that, but the judge can't ignore the grid rules if that's what you're asking. Rebecca, you are very welcome, and I wish you the best. I know I didn't give you the best news, but I wanted to tell you what the score is, what the truth is. Okay, Steph says, thank you so much. Thank you for visiting with us, Steph. I really appreciate that. Okay, Luke, I was suffering with IBS for 20 years, but only consistently pursued medical treatment in the last 2. Did try medication 20 years and made my pain worse. Again, if you are working up until 2 years ago, then, it's assumed that you were able to work through whatever problems you had. And if the last 2 years has gotten a lot worse and you had to stop working, now you're going to the doctor. Now you're pursuing medical treatment. That's not inconsistent. So I don't think that you're going to be blamed or held against you. Here's my dog. Just came to join me here. This is Sadie. I don't know if you can see Sadie, but Sadie is a beautiful black and white golden doodle who loves attention. So she will be, I'm sure, asking to be petted as we go through here. But she decided to come down and visit. Hello, Sadie. All right, Sadie, I'm doing a live stream, so you will have to go sit over there. Maybe people can see you. Okay. But anyway, I don't think it is a problem on your case. No, if you're now not able to work. How do you find a CRPS lawyer specialize in South Carolina and go back to, lawyer is great, but 3 years of case, a long time, the second time filing? I mean, there's no such thing as a CRPS lawyer. It's just you have to have somebody that understands CRPS and can ask the right questions as far as getting the evidence from to the doctor. It's really more about the doctor than the lawyer. Okay, Sadie, enough. Excuse me. I told you she loves attention. So it's not really about the lawyer, it's more about the doctor and the evidence. Okay. And okay, Medicare, I think I said that. That's Cal's website. Okay. How would somebody get SSDI and SSI? They would have to have a low earnings record so that their earnings are below the SSI amount. And SSI in 2024 is, I believe it's $943. So if you have your disability SSDI amount is let's say it's $900, you would get $900 from SSDI and $43 from SSI. That's how it works. So it's pretty rare. I would tell you in 30 years, I've had 3 or 4 people that get both. It's just pretty rare. Now, sometimes you'll get SSI for the 5-month waiting period. So you get a check for 5 months, and then once the SSDI kicks in, it offsets the SSI. So you may get 2 checks or 2 deposits. Again, that's also kind of rare, but it does happen more often than someone getting both ongoing. But the interesting thing is if you get even $1 of SSI, you get Medicaid. And obviously SSDI, you get the Medicare, but a couple of years down the road. So, theoretically, if your main focus is getting medical insurance, the amount of your SSDI and SSI benefit may be irrelevant to you. So in that case, having a low earnings record is not necessarily a big problem. Although again, it's pretty rare that you see that. Okay. Joe, I'm on SSDI short form. Okay, so the short form is when they ask you just like 5 or 6 questions. Really, you got it in a month. I guess maybe that's before they stop doing the one. Again, you may not hear anything at all, but you maybe 3, 4, 6 months before you hear anything, which is kind of bad, but that's what they do. I think Mark's files at Recon, if I'm not mistaken, is what he said. Her Majesty. We've had a princess, we've had Her Majesty, so we get a lot of royalty here tonight. I was found disabled in December 2019. My award letter has been reviewed in 5 to 7 years. I'm 60. Should you be reviewed? You're not. I think it's pretty unlikely. I think it's probably if you're 60, unlikely. I think it's unlikely. It could happen, but I wouldn't bet on it. No, I don't believe taxes are withheld from disability overpayment. Overpayment? You mean the lump sum? Overpayment says you were overpaid. I'm not sure if that's what you meant. The dude. Okay, the dude was here last week, and we talked about. And again, I can't remember the name of the movie. Somebody's going to tell me what the name of the movie with the dude was. But the dude was a character in a movie. Tammy, hi there. Clayton, thank you. Jen, thank you for all you do. Jen has to say nice things because she's my paralegal, although I'm sure she means it. But she does have to say nice things. That's a requirement, part of her job. Okay, I'm 56, waiting determination, 38 years straight, stopped working, major revision spine surgery. You got a winning case, I think. I mean, I hadn't looked at the record, but if you called me, I'd say that's a pretty strong case. Taxes withheld from back pay, I don't believe they are. No, that was the question before. No, I don't think so. What are my chances of being 60-year-old computer replacement for roofing? They've been approved. I think you got a good chance. I do. Because at 60, you're going to grid out, I believe. I don't know this judge, but really productive. Yeah, I think that's the right way to approach this. Absolutely. Jen's getting some fan mail here. Yeah, Tammy, I think you've got a strong case. I really do. Absolutely. Yep, I think it's a winning case. Powderpuff, my pleasure. John was awarded just starting part-time work. When to notify. That's a good question. They tell you they're notified. I don't know who you really notify. I think the real question is, you need to keep track of your earnings. And are you at the trial work period level? And remember, trial work period, let's go take a look, is, I think, $1,110 in 2024 gross. So if your earnings are below that, I wouldn't worry about it as much. If you're over that, you want to keep track of them very carefully. Because if you use up your trial work period, then you go over SGA, you risk being an overpaid. So, as far as do you notify them, some people say yes, some people say they'll find out, they'll know. I don't know that it makes a huge difference depending on the numbers, what you're earning. I would probably almost say, I don't know who to tell. That's the big question. I don't know who you'd even notify at this point. So that's a judgment call on your part. I can't really tell you yes or no because I just don't know who to even tell you to notify. I just, I guess my concern is that you notify Social Security that you're working. That could have negative implications. If they're going to see it anyway, let them find it. Is kind of my take. Kelly says, I really think someone told me to be on chronic pain meds for a failed back, nerve root radiculopathy, red flag. No, not at all. I don't think I disagree with that. That's what else you're going to do. I think being on pain medications, if they're prescribed and you're under pain management, nothing wrong with that at all. Tammy keeps adding. I think you got a winning case, Tammy. I promise you. Hoping to meet a listing. That could be more challenging. I think you could certainly argue, look at the listings, go to meetalisting.com and you can go through there. Look at the grid rules, because I think you could argue for both those, and those are both two recipes to get approved early. But tell them which listing, tell them which grid rule. Is it 202.06? That's pretty common. But tell them. But yeah, you might meet a listing, you might meet a grid rule. And I hope you do. I hope you do. But don't give up, because you got a winning case, is what I'm saying. James, I think you're a circadian rhythm guy. Yes, you're welcome. Yeah, Rodney, you're right. Having long-term disability to help you while you're waiting makes a big difference. Raoud, I was diagnosed with herniated disc and spinal stenosis. Had my hearing with the judge. He's willing to collect he's waiting to collect all medical records. May I get benefits in the past? Yeah, your record was left open, so you want to get those records into the judge, and then hopefully the onset date that you were approved for, if assuming you're approved, will go back a number of years. You get a nice lump sum. Yes, Tammy, the grid rules do apply. And yes, you should submit this. Yes, you absolutely want to say, please evaluate this case under grid rule 202.06 or 201.06, whatever one applies. Please evaluate this case under listing 1.14, whatever it happens to be. And definitely ask them to do it. What does it mean the appeals council denies you in 3.5 weeks? That is a little unusual. Yes, that's unusual. They usually take longer than that. That means that there was something pretty significantly flawed in your argument for appeal. I don't know what that was, but that's pretty unusual. Deb, she's talking to the person, Chrissy, about the CRPS. Yeah, there's not really a CRPS lawyer. You got to find it. That's exactly right. Find a CRPS medical specialist. Yes, video is acceptable to them. They used to do a lot of videos. Yes, so video is absolutely acceptable if you can't get to the doctor. Chrissy likes my dog. Yes, she's actually a very sweet dog. She's like 4.5 years old now, and she's golden doodle. She's big. She's 75 pounds. Very, very sweet. Very good natured, very friendly, likes a lot of attention, likes to be petted, likes to play. Very affectionate, loves treats, and she's just a good dog. I mean, she's a good dog. She can be a little rambunctious at times when, like, you come home, it's like she thought I'd been gone for 3 years. But she actually, interesting story about Sadie. Her sisters, she has 2 sisters that were bred. She was part of a program. She was bred to be a service dog for people with medical problems, and 2 of her sisters do that. One of them works for a young lady who's got seizure disorder, and so this dog Nova is trained to jump under the young lady who's got seizures and basically prevent her from hurting herself. And the other one's Winnie is a psychological service dog, basically a young woman with some psychological issues. I don't know exactly what they are, but Winnie is a service dog and helps keep her calm and things like that, and goes with her everywhere. And Sadie was a part of that program, but she was a little too rambunctious, and so she was asked to leave. But Sadie is a really smart dog, and I've been able to train her to do a lot of things. She's very, very sharp. My son has a dog. My daughter and son-in-law have a dog. Good doodles as well, and they're good dogs, but Sadie's by far the smartest of all of them. So just happens to be the truth, and the best looking of all of them too, despite my son's protesting. Okay, Kelly. Oh, well, my pleasure, Kelly. I'm glad to do it. This is fun for me, and it's a good chance to, obviously you get really busy, and I get a lot of emails, and I can't answer all of them, and I refer out to people when I get really busy, but this is a chance once a week where I'm here for anybody who wants to chat. So I enjoy doing it. Is there a statute of limitations bringing an appeal for a person approved for new grid? Why would you appeal? If you're approved in 99, you're still getting benefits. Why would you appeal it? I mean, if you get a CDR and you want to add it, there's no statute on that. You can add it whenever. Because if you're reviewed for a CDR, then what they're going to look at is, are you still disabled? And so if there's new conditions that have arisen that make you, and as a recent date, they're not going to say you were not disabled 5 years ago. They're going to say you became not disabled, now. So if you've got new conditions, bring them up now. That's when you would bring them up. Can a person in their 40s receive disability for spastic gait, cerebral stenosis? Yes, you can. Absolutely, you can. That's a pretty severe problem you're describing there, and that might be one of the few that would pass muster if you're in your 40s. Yeah, I think it is definitely viable. It's always harder in your 40s, but that would be one where you might actually make it. Wolfgang. I'm on appeal after being denied for religious 3 times. I have pain in rehab, mental health, car accidents. Only 45. Yes, your age is holding. I would think your age is holding you back. Absolutely. And you can see, folks. Here's a person, Wolfgang, who has been denied 3 times. Had multiple car accidents. Probably has a lot of evidence, but because he's 45, they just keep denying him. So, Sherry's husband is 60, had major back surgery, then diagnosed. Stage 4 lung cancer. lost his job in hospital, but yeah, that's a compassionate allowance case. In that case, you file it and just reference he meets the listing and also a compassionate allowance. If you look up compassionate allowance, you'll see that stage 4 lung cancer is a listing level impairment and is one that would be approved for compassionate allowance. I know this because I had a friend I grew up with, pardon me, who unfortunately had stage 4 lung cancer. And he called me and we got ahead and got the doctor to fill out a statement of the listing, submitted it, got him approved in about, I think, 6 months, which is more than it should have taken. And so he got he got his benefits. Unfortunately, he passed away about 5 or 6 months after that. But that was a listing level compassionate allowance case. So that's what I would do, Sherry. He definitely should be approved. Tammy is back. Work history form and pain questionnaire. Yeah, it depends on the DDS office, but that's not that unusual. Not that unusual. So again, you got a winning case, I think. Sherry was denied. You're kidding me. He's 60 years old, back surgery, lost his job. I mean, that is nuts. That is completely nuts. I mean, if you call me or email me, ssdanswers123@gmail. That's crazy. That is absolutely crazy. Unless if you already have a lawyer, tell your lawyer, get on the stick. But if you don't, call me because that's crazy. There's no way that your husband should be denied. Absolutely no way. Yeah, Chrissy is the one. You may have just had a judge who doesn't buy into CRPS, and if you still have time to appeal, maybe you're 34. That's the problem. You're 34. That's the problem. It's going to be really hard because of your age. Christina says, don't forget. Christina is reminding everybody, which I really appreciate. Christina, she's a regular, and she's like, please like, share, and subscribe. Yes. And please leave me a review. I'll put that up here again. If you like this, please leave me a review. That would be really helpful too. Okay, we got about 15 minutes to go. I have a CDR appeal tomorrow, hearing tomorrow, hope they overturn their decision. Any tips? Just really focus on those things that make you not reliable at work. Be very specific. Not, I can't stand very long. I can't sit very long. I can stand for 10 minutes and I got to sit down. I can sit for 15 minutes in an office type of chair, then I got to stand up. Be very, very specific and just talk and, let the judge know you'd much rather be working, but, you just can't. And your condition is not improved. And, you've done everything you can to try to make it improve, but it just has not worked. And, you're a very reluctant claimant, but be specific. That's the main thing people don't sometimes do. Compassionate allowance, again, that's what I think would be appropriate in Sherry's husband's case. Troy, you are welcome, Troy. Thank you for tuning in. Sabrina, my husband applied 9 months ago in Texas. Yeah, Texas is bad. This is exactly what's going on in Texas. They haven't even assigned an adjudicator, and several states are like this. I would reach out to your U.S. Senator, Cruz, or whoever, I'm not sure the other one is, but ask for help because that's ridiculous. Yes. They don't technically stop until you're age out of the program, but I would tell you that at 55, it's pretty rare they would review you. At 50, it's unusual. Below that is more common. But again, I think suspended them for the rest of this year. But I think once you hit age 50, I think you're doing pretty good. You're smooth sailing. Walter Knott. Yeah, Walter is, he's on all the time. Walter does a lot of live streaming. I think it's HNOT is how he spells it. But Walter is very, very active on YouTube. And he's got Walter's a New Yorker, I'm guessing, because he talks really fast. But he knows a lot. So Walter's got some good stuff. And, again, I think you should take advantage of all of the resources out there. I mean, I hope you found this useful. Walter's, on a lot. He takes phone calls even at times. And, I think he's keeping busy. He and I have corresponded a few times. Never met him in person, but he seems like a nice guy. And I suspect he, based on what I can tell, he knows what he's doing. So, he is on a lot. He's on a lot. I just kind of figure once a week is good for me. And that way, because I'm busy, I'm really busy. So once a week is fine. Yeah, Deb, I would agree with you. Age is a major factor. Age is a big, major factor. Keep bugging you. No, you're not bugging me. Somebody says approved in April, so we're going to medical approval. Got a call. I don't think it's going to make a difference if you go there, but I think, it couldn't hurt. But I think this might be one where, reach out to your U.S. representative because that's taking way too long. All right, DC, have you ever had a case with a physical test doctor, a lot of paperwork, the doctor to perform tests? Yeah, I've seen that before. And I think what I would do is I would write out very clearly to your recollection what actually happened. And if you go to a hearing, have your lawyer submit that and have it written up in a statement form that, you basically you want the judge to give little to no weight of the CE exam because it's inaccurate. These things did not happen. In fact, one of my colleagues, I'm drawing a blank, Michael Liner, he sent me he's got a form he gives all his clients when they go to CE appointments to fill out as soon as they come back that basically says what happened. And if the report is different than that, then he uses that form to argue for that the report should be given little weight. And maybe on Michael's website, you may be able to find that form. But I'm just telling people, just write down what happened, how long what the doctor did, and just make notes at the time of your CE appointment if you can. And then if the report comes back, and what I typically do is, if people want it, I'll get that report for them. Usually it comes down, it's posted about 2 weeks after the appointment. And so I'll get it and send it to my client and say, is this accurate? And if it's not, tell me why not. And we'll, as part of my brief or as part of, as a piece of evidence, I'll submit a statement saying that why this is not very good or not accurate. Nasif, can a person in their 30s receive disability for scoliosis? Dad, I actually won a case for somebody in their 20s with scoliosis a number of years ago. It's got to be really bad. I mean, in this young lady's case, she was actually going to school, which is considered SGA in some cases, but she was only able to take like one class. She had to get a special ride to her classes, special accommodations all in the class and transportation and so forth. So it can happen, but it's got to be really, really bad. And I think that I can't remember what degree it was, but I mean, her spine was just, it was like an S. It was really bad. And that was an in-person hearing, but that was really bad. But the answer is yes, Nasif. 56, Carolyn says, numerous issues, rheumatoid, degenerative disc disease, PTSD, inflammatory arthritis. Spoke with vocational day with a decision 2 weeks chances. No hearing. I mean, you always have a chance. At 56, you might have the grid rules that go into play. So I'd say, given the grid rules and given your age, you got a decent chance. Now, recon is the lowest approval level. So at recon, if you're, I think you're, I don't know, you may not be a recon. Maybe you're an initial. Initial, about 35% of cases get approved. So I think you got a decent chance at it. Hopefully you will. I mean, there's no way to tell exactly, but I think you got a decent chance at it. A hidden is 54-year-old female with severe IBS, left artificial hip, et cetera, et cetera. Yeah, that is I think that's a pretty strong case. 55, I win a lot of IBS cases because if you have to use the restroom on a constant basis without being planned and you're in the restroom for a long time, that is really hard to, very, very hard to work. So I think that is, that's a good case. I do a lot of IBS, have a lot of IBS cases, and we usually win them. You're asking a tax question. If it's, you'll get a 1099, so you'll have to deal with it in that regard. I'm just hearing compassionate allowance, both no income, but wording for inheritance. No, inheritance will not affect you for SSDI. And compassionate allowance, just type in compassionate allowance and just find the one and just tell the Social Security, please evaluate under compassionate allowance. Thank you, Al Aberlado Yasso. I love your program. Thank you. I'm 63, taking medication for Parkinson's and rheumatoid. To me, their doctor, I'm close. You should be getting close. I mean, a lot of these cases get approved at the administrative level, and I think that you got a good shot at 63. Absolutely. I hope you win. I mean, Parkinson's, as you know, is tough. DC, my pleasure. Mrs. K. Hello. How are you doing, Mrs. K? And Deb is responding to Sherry, I think. Yeah, do an emergency. I think she's right. Did grid rules apply at initial determination? Yes, absolutely. I win cases with grids at the initial all the time. In fact, when I do an application, I frequently will say in the application, please evaluate under grid 202.06. I'm amazing. Well, passing. Free case evaluation. Yes, that's Garrett again. Caroline, you were welcome. Angela, there should be a new category of PTSD for the process. Yeah, I hear you. The process of applying for SSDI. Most people have probably dealt with years of misdiagnosis. Yeah, I don't disagree. That could be. I've never made that argument, but I think it could certainly be one you could make. Okay. A hidden. I don't know what a hidden did there. Okay. Oh, here we go. Oh, it looks like that's the last comment. Okay, well, oh, wait a minute. We got a couple more coming in here. Let's see. No, maybe not. Okay. Well, anyway, I think let me take that off here. But yeah, big picture here is, I mean, it can be very, very, it can be, Sherry. Okay. Okay. We got some more coming in here, Sherry. Okay, good. Thank you. I'm glad that you came across my page as well. Can I get my wife to do more workers' comp videos? I'll try. I mean, we've got a few in the can. I typically write up the description there, so I'll ask her, but I'll try to get more out. Tat, I know I owe you a phone call, and I know. Okay, Christina, thanks for all your help and support. Have a great week. You are very, very welcome. Okay, we got 5 minutes to go. My husband was acting strange again. Then he left me, decided to leave. Found Dr. Okay, come on. Let's not do this. Okay. We gotta. Okay, very good night. Good luck tomorrow. Thank you. Do you know if let's say other issues what cause standing walking? Discs. Okay. Do I know if discs cause standing and walking issues? Again, that is common, but there could be any number of things causing standing and walking issues. Your knees could be a problem. There could be some sort of, vascular problem. There could be some sort of a, muscular problem. There's any number of things that could cause it. But I think having a good diagnosis would be very, very helpful, because it's hard to go into disability and say to the judge, we don't know why I'm having all these problems, but I am. It's called idiopathic, and idiopathic conditions are really hard to win. Annie says, please, it's Jonathan, not Mr. Ginsberg. You can see I'm already getting kind of old with the gray hair and everything here, but it's Jonathan, not Mr. Ginsberg. Okay, but you're welcome anyway. I just had my second back surgery. This time a fusion, not better. Have severe diabetic neuropathy, blah, blah, blah. JC, depends on how you just filed. How old are you? I think if you are, if you were old, if you're over 50, your chances are much better. So that just depends on how old you are, really. But I think you've got significant problems there that I think would, even if you're younger than 50, I think it's still an issue. Still got a good shot at it. Spinal stenosis. Okay. Again, those are things, Mrs. K, that are very, very limiting on work. Stenosis and weak legs and things like that. That bodes well for you. 57, broke your femur at work, had both knees replaced, won a total revision, bulging disc, recon stage. So same doctor might not hear. Yeah, I mean, again, at 57, you can meet a grid rule and look at the grid rules, 202.06 in particular. Even if you could do limited work or light work, you're still potentially disabled. So I think you got a good case there. JC says that he or she, I don't know if it's a he, I'm assuming a he, is 53. Yeah, that then you meet, I think the grid rule at sedentary would apply. I think you got a good case. Okay, Christina. Yes, my wife is a very good workers' comp lawyer. Workers' comp is state by state. You know, people say, you know, why doesn't she do these? Because there's a lot fewer. I mean, I'm talking to people about disability. I can do cases all over the country because it's all done by phone or video. With Jody, my wife, workers' comp is state. She does this whole state of Georgia, but she doesn't do cases in Virginia or Florida or California. So, you know, it's just a smaller market, as it were. And she's really busy. She's really good. She's you know, she does not take prisoners. Workers' comp is very adversarial, and I would not want to go against her because she's tough. She's tough, and trust me, I know she's tough. You're welcome. You are all welcome. Okay. Lost Brooklyn, PAD, plantar fasciitis. Plantar fasciitis, again, is going to limit you from walking, probably not enough to win a disability case. PAD, I'm not sure what, I've heard that before, is the peripheral artery disease. Okay, that's what you mean. I mean, that's a significant problem. That's real significant, more significant than plantar fasciitis. So if you've got peripheral artery disease and possibly some DVTs, that would give you a real strong argument for disability because that's really hard to treat and hard to work when you have to keep your legs extended. That's the big problem that happens. You have to keep your legs extended. And that's just really, really hard to do. So I think that peripheral artery disease can be a really, really strong basis for disability. Okay. And the state does not, most states probably not. I know there are some states where actually they do. But it just depends on your state. You might want to check with the state government to see if there's any program that you could get paid as being a caregiver. I know in New York, I think they do. I don't know where you are, but in New York, I think they do. I've had people that do that. I've got a case coming up for hearing right now, and my client is a caregiver, so he's getting paid by the state to do it. So yeah, it does exist. It does exist. But I would call your state government to see if there's any program to that effect. I will be going. Well, Kevin, first of all, it'll be you can get the replay. You can look at it on YouTube, just under the live section. It's recorded, and I go on every Wednesday night at 8:30 p.m. Eastern. Every Wednesday, 8:30 p.m. Eastern, I go live. So, if you are Sherry's in Maryland. I don't know about Maryland, but again, it's worth calling, worth looking into. But yeah, Kevin, I go live every Wednesday at 8:30. And yes, Sherry, I've done plenty of cases out of Maryland, and again, I think it's a reasonable place to pursue disability. 5:30 Pacific, 5:30 Pacific, 8:30 Eastern. Make sure that's clear because I don't go in at 5:30 Eastern. For Kevin. Okay, Kevin must be in California. So okay, so if you're in California, 5:30 and 8:30 Eastern. But yeah, it's all recorded, so you can go through it. I know one of my buddies. He'll take snippets out of the live streams and put it as short video shorts. I haven't done that yet, but that may be something we look at doing at some point down the road. So, okay, well, we are at the 10:30. I guess it's probably 7:30 in California. So I'm going to end it now, but I appreciate everybody's time. Thank you very much, and we will hopefully see you all next week or in future Wednesday nights. And again, if you want to reach me directly, go to ssdanswers.com. You see the link down there. The bit.ly is there, but it's ssdanswers.com is a website. ssdanswers123@gmail is my direct email if you would like. Jen knows that because she is very familiar with how to reach me. And we will hopefully see everybody next week, and try to stay cool out there. Have a very safe and healthy rest of your week and weekend as well. So take care, everybody. Bye-bye.